accused 3 and 4. Accused are have a trust running certain education institution. One of the condition under the MOU, condition number 5, says these complainants are to bring an investment of 10 to 12 crores to make payment with regard to certain bank loan. Apart from that, interest-free investment of 10 to 12 crores was contemplated. Pursuant to that, complainant made a payment of 1.53 crore to Federal Bank on 29/12/2012, an installment of the loan. It was not clearing of the loan. On condition, a promissory note was taken from the present accused, charging 16% interest. The other complainant on 29/12/2012 has shown 30 lakhs as loan to the trust at 14% interest with a promissory note. Again, a promissory note and an assignment deed of the properties to his trust. All these transactions were not the one contemplated under MOU. When these properties were got assigned to his trust, disputes started. It was pointed out the required investment of 10 to 12 crores to be brought in. Immediately, all the bank loans were to be discharged. These disputes with regard to the contract between us. After getting the properties assigned in his favor, neither did he bring the installment nor allowed us to continue the education institution or development or anything of this sort. As a part of performance of that MOU, a resolution was passed on 7/1/2013 to induct him as a trustee. After this also, there was no further action by them either to bring in the installment or to discharge the loan of the bank. Then on 3/5/2013, legal notice was issued saying you will not be a trustee anymore. You are not brought in the capital that was required to be brought under the MOU, and all those contentions were taken.
Now, B report is filed by the police.
Then the B report is filed. As regards the acceptance of the B report, straightway the matter is covered by the decision of this court in as much as
Ravi Kumar.
not even a single sentence is said what is that B report, how it is not acceptable, or what fault the court finds on the B report. That decision of Ravi Kumar is
But court has directed further investigation.
further investigation
He need not accept or reject the B report.
on a protest petition.
Correct.
If it is to be done on a protest petition, as per the decision of this court, he will have to say, I am not accepting this B report for these reasons. Or B report, the investigation in the process is not proper, therefore the necessary of further investigation. Kindly see, I have given that on memo jotege citations ಕೊಟ್ಟಿದ್ದೇನೆ.
ಕೊಡಿ ಇಲ್ಲ ಇದೆಯಾ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ಸೈಟೇಷನ್ ಲಿಸ್ಟ್ ಆಫ್ ಅಥಾರಿಟೀಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ
ಇದು ಕೊಡಿ. Apparently, your lordship may kindly go to para 4 end or typed page 5. On the other hand, it is seen that immediately after filing the protest petition, learned magistrate has proceeded to provide an opportunity to the complainant to give her sworn statement before the court and also recorded the statement of the witnesses and thereafter proceeded to issue process against the accused by rejecting the summary report. The procedure followed by the learned magistrate is not in accordance with law. It is well recognized principle of law that once the police submit B summary report, protest petition is filed to the same. Irrespective of the contents of the protest petition, the court has to examine the contents of B summary report so as to ascertain whether the police have done the investigation in a proper manner or not. If the court is of the opinion that investigation has not been conducted properly, court has got some options to be followed, which are the court, after going through the contents of investigating papers, is of the opinion that the investigation has not been done properly. The court has no jurisdiction to direct the police to file charge sheet. However, the court may direct the police or for or further investigation and submit a report, which power is inherent under 156(3) of CRPC. But before taking cognizance, such exercise has to be done. This, my view, is supported by the decision of the Honorable Apex Court in the case of AR 1968-117, Abhinandan Jha, and also full bench decision of the Apex Court reported in 1980 SEC 91 between Kamlapati Trivedi. If the court is of the opinion that the material available in B summary report makes out a cognizable case against the accused and the same is sufficient to take cognizance and to issue process, then the court has to record its opinion under 204 CRPC and court has got power to take cognizance of the contents of B summary report and to proceed against the accused. If the court is of the opinion that B summary report submitted by police has to be rejected, then by expressing its judicious opinion, after applying mind to the contents of B report, court has to reject the B summary report. After rejection of B summary report, court has to look into private complaint or the protest petition as the case may be and contents therein to ascertain whether allegations made in private complaint or in the protest petition constitute any cognizable offense. And then it can take cognizance of those offenses and thereafter provide opportunity to the complainant to give sworn statement and also record the statement of witness, if any, on the side of the complainant as per mandate under section 200 CRPC. If the court is of the opinion that the materials collected by the police in the report submitted under 173 CRPC are not so sufficient, however, there are sufficient material which disclose a cognizable offense has been committed by the accused, the court can still take cognizance of the offense under section 190 read with 200 CRPC on the basis of the original complaint or the protest petition as the case may be. After taking cognizance and recording sworn statement of the complainant and this.
Now, when a B report is filed,
Please,
he has two options.
just for
Accept the report or reject the report.
yes,
Or direct further investigation on inherent powers under 156(3).
recording that the investigation as done is not as found in B report is not.
That
Your
is,
Lordship, may kindly
that is
see
to
the
reject the B report.
order in the
Reject the B report and take cognizance under 204, proceed the 204 way, he has to give elaborate reasons.
kindly see the order passed in this case.
Order passed in this case.
Page 85.
85, yes. Order dated 6/7.
Complainant present. Advocate for complainant urged that there are sufficient material to probe into the matter as accused persons under the guise of running education institution have misappropriated huge funds which was advanced by the complainant and the transaction has transpired through bank transfer. But unfortunately, investigating agency has closed the matter and bent on filing B report on the count that matter is in civil nature. That after hearing the complainant's counsel, justice demands for further probe the matter. Hence, concerned investigating officer so and so is directed to reinvestigate and file the final report. This is the, not even a word about the B report or what is that court found.
That is to reject the B report, he has to give reasons.
Even for further investigation, there will have to be a finding that as from the material available, there is.
No, if he says these are the materials have to be investigated into in further investigation.
No, it is not.
That would not be
It's
correct.
not even that, my lord. I will read it again. Complainant submits that there are material amount is transferred from bank.
Misappropriation of funds ಅಂತ ಹೇಳಿ.
Complainant submits.
ಹೌದು.
Kindly see the next word. That after hearing the complainant, justice demands for further probe. I would respectfully submit. It is like saying, I have perused the papers. It is not even that. It's not even that. With regard to a B report, which is already on record, my respectful submission is, it's not that they don't have the power to, it will have to say, this material is not available in the B report. Minimum that was required to be said is, complainant points out so and so. This part of it is not available in the B report.
That is the protest petition.
It's not even that. That is why what I am pointing out is, minimum is, I would dare say, he did not, if the learned judge did not even open the B report. The transfer of money or advancing of money by them or investing it in the trust is something which was to be, that is not the complaint, first complaint. That's not in the first complaint. The allegation, this allegation, if it were to be looked into, minimum was that. Of course, my lord, it is with regard to the order as made. What I am pointing out is, the minimum that was required to be seen is whether the complaint first or the additional complaint after seeing the draft report, etc. Whether any ingredient of offense is made out other than civil transactions. It is that which we have said. But there is one this thing. The other accused have filed it, are filing it today, my lord. I think
Same order.
Same order.
Yes.
That is ಅದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಕ್ಕಾಗಿ ಆ ಮೊದಲಿಂದನ್ನ
ಇದು ಬಿ ರಿಪೋರ್ಟ್ ಅಲ್ವಾ?
ಇದು ಬಿ ರಿಪೋರ್ಟ್. ಇಲ್ಲಿ ಸ್ಟೇ ಇತ್ತು, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಲಿಲ್ಲ. ಆಸ್ ಪರ್ ದಿ ಸ್ಟೇ ಆರ್ಡರ್ ಪಾಸ್ಡ್ ಇನ್ ದಿಸ್.
ಬೇರೆಯವ್ರ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರಾ?
ಬೇರೆಯವ್ರದ್ದು ಹಾಕೋದಕ್ಕೆ ಬರ್ತಿರ್ಲಿಲ್ಲ ಬಿಕಾಸ್ ಆಫ್ ದಿ ಇಂಟರಿಮ್ ಆರ್ಡರ್ ಪಾಸ್ಡ್ ಇನ್ ದಿಸ್ ಕೇಸ್. ಬಟ್ ಸ್ಟಿಲ್ ದೇ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್. ದೇರ್ಫೋರ್ earlier petition was withdrawn and a new petition is being filed today.
ಅಲ್ಲ, ಇದು ಬಿ ರಿಪೋರ್ಟ್ ತಾನೆ. ಇದು this is a direction for further investigation.
It is.
A further investigation ಆಗಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಾಗಿದೆಯಾ?
ಹೌದು.
Okay. What has happened before the court then?
ಇಲ್ಲ, ಇನ್ನು ನಾವು we have ಅಲ್ಲಿ ಕಳಿಸಿದ್ದಾರೆ. ನಾವು we have filed the petition.
Court, the concerned court has not yet
ಇಲ್ಲ,
looked into the charge.
ಅಲ್ಲಿಗೆ ಇನ್ನು ಇದಾಗಿ
ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಮಾಡಿ.
ಅದೇ ಅದಕ್ಕೆ ಅದನ್ನ ಇವತ್ತಿಗೆ
ಬೇಡವಾಗ?
ಫೈಲ್ ಮಾಡ್ತಾ ಇದ್ವಿ.
ಇದು ಕನ್ಸಿಡರ್ ಮಾಡೋದು ಬೇಡವಾ?
ಈ ಎರಡನ್ನು ಕೂಡ ತಗೊಳ್ಬಹುದು ಅಂತ. ಯಾಕಂದ್ರೆ ನಾವು 480 crashing ಕೇಳ್ತಿದ್ದೇವೆ. This is part of the relief pointing out there is no application of
Then
mine.
now that the charge sheet is already filed, you withdraw this, we'll consider that.
ಇಲ್ಲ, ಇವ್ರ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ, ಅವ್ರ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಅದನ್ನ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡು we have filed the fresh petition is being filed today. I think we'll get the FR
Being
number.
filed today.
ಹೌದು, ಮಾಡ್ತಿದ್ದಾರೆ, ಆಫೀಸ್ ನಲ್ಲಿ ಹೋಗಿದ್ದಾರೆ. ಬಟ್ ಇದಾಗಿದೆ. ಅದ್ ಯಾಕಂದ್ರೆ ಕ್ವಾಶಿಂಗ್ ಕೇಳ್ತಾ ಇದ್ದೇವೆ ನಾವು. ದಿಸ್ ಆರ್ಡರ್ ಇಸ್ ಓನ್ಲಿ
No, this order is only against this petitioner.
ಅಲ್ಲ, ಇಟ್ ಈಸ್ ಸೇಮ್ ಫಾರ್ ಆಲ್ ದಿ ಅಕ್ಯೂಸ್.
No, reinvestigation ಎಲ್ರಿಗೂ ಆಯ್ತು. ಸ್ಟೇ ಮಾತ್ರ ಆಗಿದ್ದು ಈ petitioner ಗೆ ಮಾತ್ರ.
ಸ್ಟೇ ಈ ಪೆಟಿಷನರ್ಗೆ ಅಂತ ಇಲ್ಲ. ಆಕ್ಚುಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್, they could not have filed the charge sheet.
Oh,
But they have.
how many petitioners are here?
Two petitioners here.
ಇಲ್ಲಿ 2 petitioners.
ಇವರಿಬ್ಬರ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲ.
Pure April Mele because of the state
It says where the petitioners.
My lords.
Order of 2-9.
It's always.
Can I just explain, my lords?
Both the petitioners are
Totally
affected.
8 accused. My lords, totally 8 accused. Out of 8, 4 are dead.
For a
For
date.
a day. So petitioners accused 3 and 4 filed the present petition, my lords.
1 and 2 charge sheet ಆಗಿದೆ ಈಗ.
Illa, 1 and 2 dead. 1 and 2 dead, 5 and 6 dead. Accused 7 and 8 preferred another criminal petition. In that, there was no order of stay. So investigation continued. Charge sheet has been filed insofar as 7 and 8 are concerned. So far as 3 and 4, who are the present petitioners, by virtue of this stay, the investigation could not be completed. That's all that has happened, my lords. So probably, my lords, if this further investigation goes on and if there's a charge sheet, they can challenge it together.
I will take my chance in pointing out that the complaint is, it's a fit case for quashing the complaint here.
No, that's not the prayer here.
Yes, yes.
ಅಲ್ಲ, ಇದು quashing the complaint order.
ಅಲ್ಲ, quashing the complaint ಕೇಳಿದ್ವಿ.
Accept the B report.
Where is quashing the complaint?
Caution.
B report ಮಾತ್ರ, order ಮಾತ್ರ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು.
And accept the B report ಅಂತ ಹೇಳಿ ಕೇಳಿದ್ವಿ. But now.
So it revolves around the B report ಅಷ್ಟೇ. B report is what you read. We'll consider that. Whether the court could direct further investigation or not.
ಆ ಮ್ಯಾಟ್ರ್ ಜೊತೆಗೆ ತೊಗೊಳ್ಳಿ, ಇದ್ರಲ್ಲೂ ನಾವು ಕ್ವಾಶಿಂಗ್ ಕೇಳ್ತೇವೆ. ಕಂಪ್ಲೇಂಟ್ ಕ್ವಾಶಿಂಗ್
ಅಲ್ಲ, ಅದಕ್ಕೆ ಅದು ಬೇರೆ ಮಾತು. ಅದು ಅವ್ರಿಗೆ ಆಗುತ್ತೆ. ಇಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಕ್ವಾಶಿಂಗ್ ಏನ್ ಕೇಳಿಲ್ಲ ಇದ್ರಲ್ಲಿ ನೀವು.
ಕಂಪ್ಲೇಂಟ್ ಕ್ವಾಶಿಂಗ್ ಕೇಳ್ತೇವೆ. ಅದೇನ್ ಇಟ್ಸ್ ಎ ಮಿಸ್ಟೇಕ್ ಇನ್ ದಿ ಪ್ರೇಯರ್.
Let the further investigation go on in this also. ಒಟ್ಟಿಗೆ ಮಾಡಿ. I will answer this question.
It's a 100% fit case for quashing the complaint.
That's all right. But ಈಗ ಕೇಳ್ತಿರೋದು B report.
ಅದಕ್ಕೆ
That also I will not interfere for this reason. Police have filed the B report. The court has directed further investigation. There is no question of interdicting further investigation here.
It's not question of interdiction.
Then what?
If I am to make out on the complaint, there is nothing that is required to be. This is
Not at the stage when court has directed further investigation.
even with further investigation. I will point out if the ingredients are not there.
The interim order is taken on the ground that it violates Ravi Kumar. Now you cannot say, go put the clock back and say that I will question the FIR also. That is registered. B report agogide. What can you question? The complaint, private complaint that is registered. ಅದಕ್ಕೆ private complaint register agi, that has not culminated into anything today. It's presently culminated into the B report. That is now further investigation.
It's like challenging the FIR itself. That itself can be done.
Not at the stage of direction of further investigation.
It would be, my lord.
B report challenge ಮಾಡಿದ್ರೆ we'll answer it.
B report in the.
ಇಲ್ಲ, we'll direct, you cooperate with the investigation. ಅವರು ನಿಮ್ಮ ಮೇಲೂ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರೆ ಒಟ್ಟಿಗೆ ಚಾಲೆಂಜ್ ಮಾಡಿ ಅಷ್ಟೇ.
ಈಗ ಇದರಲ್ಲಿ ಪ್ರೇಯರ್ further prayer is to be sought.
That's highly incorrect. Interim order is taken on a certain premise. Now when it is pointed out to by the court that you have not challenged the FIR, now you will say I will amend the prayer and challenge the FIR also. ಒಂದು ವರ್ಷದ investigation ಅಲ್ಲ, investigation ಆಗಿಲ್ಲ because of the interim order. Interim order is granted on 2/9/2024. 3 months ಅಲ್ಲಿ investigation ಆಗೋಗಿರೋದು.
The FIR, the grounds raised are against the complaint itself, FIR itself. Therefore, it's only wording of the prayer that is.
ಅದು ಯಾವತ್ತಿದೆ ಅದು? ಇನ್ನು ಫೈಲ್ ಅದ್ರ ಜೊತೆ ಏನ್ ಬೇಡ. ಅದ್ರ ಜೊತೆ ಏನ್ ಬೇಡ.
This is separate. Here the B report has to be answered, my lords, whether the court's order is justifiable or not.
Yes.
They have directed further investigation. Whether there has to be
There
due
is no
application.
warrant of interference with this order. No warrant of interference with this order. Because further investigation ಆದ್ಮೇಲೆ all remedies are always available to you.
It's not a question of all remedies available. My lord. Let me put it. The grounds raised are against the complaint FIR itself. Though prayer nella the order ಅಷ್ಟೇ ಕನ್ಫೈನ್ ಮಾಡಿದ್ರು.
Amend ಮಾಡಿ ತೊಂದ್ರೆ ಇಲ್ಲ. Prayer